I thank you, Honourable Presiding Member. Sir, I wish to restrict my comments to the amendment being proposed on the Poisons, Opium and Dangerous Drugs Ordinance. Many who have spoken about this, written about this, have primarily concentrated on the bail matters. I think the Honourable Minister in the morning, when he introduced this amendment, also stated that he will be moving some amendments in the committee stage, where over 5 grams will be to the High Court and over 10 to the Court of Appeal, if I'm not mistaken. Up to 10 to the High Court and above 10 to the Court of Appeal. So I don't want to take my time on the bail provisions, but I do want to say a few with regards to certain other provisions which I think are important, and I would expect the government to take them quite seriously. I say these comments, Honourable Presiding Member, from a very particular perspective. Now, Honourable Justice Vigneswaran is here. We belong to two different parties. We don't get on politically. But when it comes to the issue of drugs in the Northeast and the way in which drugs is being spread in society, I think we are in all agreement. The TNA, the Honourable Vigneswaran, myself, my party, even maybe some members Tamil members who belong to the government will also agree, maybe not officially and openly. But the military's involvement in this process just cannot be denied. And unfortunately, the reality is that the military has not come out of this counterinsurgency mode. They continue to act on the basis of a counterinsurgency strategy. And as a result, they are the biggest peddlers of drugs in the north and the east, particularly in Jaffna. I can tell you, as a member for the Jaffna electoral district, and by extension the police are also in it. So I make these comments with that specific angle, because when we look at the amendments that are now being introduced, when we know that the military and the police are involved in this whole exercise, then these amendments, if I may say so, Honourable Presiding Member, are actually quite dangerous. So it is in that respect that I wish to make some comments. The first matter that I wish to bring to the notice of this House is with regards to the provision that currently prevails, which is that the police, at present the police can send drugs to the government analyst department for testing, either directly or through court. Now, sending it through court is something that we have no qualms about. But to send it directly, I think is once again something that causes a lot of concern, precisely because of that very specific angle from which our experiences, which is the military's and the police's involvement in the whole drug problem that prevails in the north and the east. The Honourable Presiding Member will understand, as a lawyer, that the chain of custody is fundamental in these sort of cases, and tampering with evidence, we all know cases fail primarily because of that. So in those circumstances where there is so much corruption involved and there is so much of black money involved, I think the idea that the police can directly send these productions, evidence to the government analyst must in some way be stopped. And the court oversight, I think, becomes very, very important, particularly in the Northeast. The sooner you bring it within court, the better it is for a fair proceeding. This particularly, Honourable Minister, must be taken into account when you consider in 2020, if I am not mistaken, several members of the Police Narcotics Bureau were found tampering with productions that in fact had been taken into custody and sent directly to the governmental list, where they had taken some quantity of the productions and resold it. And if I'm not mistaken, there are cases against them. So that is an important matter that I wish to flag. The case of Nagalingam Chettiar Kandasamy versus the Attorney General, the Court of Appeal held in this way. In a case of this nature, the prosecution not only needs to prove the case beyond reasonable doubt, but also ensure with cogent evidence that the inward journey of the production has not been disturbed at all, the all material point. There is another case, Pereira versus the Attorney General, where the court stated this. It is a recognized principle that in a case of this nature, the prosecution must prove that the productions had been forwarded to the analyst from proper custody, without allowing room for any suspicion that there had been no opportunity for tampering or interference with the production till they reach the analyst. Therefore, it is correct to state that the most important journey is the inward journey, because the final analyst report will depend on that. So that is to the extent the court gives importance to the chain of custody, to the non-tampering of such evidence, and therefore the more we have court oversight, I think will be fundamental in the case of justice. The other provision that is being proposed, I think, is section 77 capital A brackets 5. Honourable Presiding Member, requires the judge to authorize the PNB or any other person authorized by the judge to photograph the evidence and can then ask the evidence to be destroyed. Now again, when you have this very high risk of tampering, of judicial officers being involved in this whole drugs cases, to have these evidence not protected and safeguarded until the very end of the trial proceedings, I think is another matter that you really need to reconsider, Honourable Minister. I wish to flag those two at the beginning, and then of course I wish to come to the main part of what I wish to state. That is with regards to compulsory rehabilitation. Now the proposed section 86 states persons will not be prosecuted for offences under section 52, which is possession and consumption, 54 selling, supplying and procuring, and 54 capital A brackets 1, B, C and D, which deals with manufacturing and trafficking in the following circumstances. A, if the quantity of drugs is less than 1 gram. B, persons agree to undergo treatment for de-addiction and rehabilitation. And C, where the Attorney General has stayed prosecution. Now, Honourable Presiding Member, whilst the face of it, this provision seems progressive, in effect, there is no choice. Because anyone would prefer to go through opt for so-called rehabilitation than to go through prosecution. And there is nothing. In fact, all the evidence that is available suggests that there is substantive evidence that compulsory rehabilitation drives persons to relapse and hence is counterproductive. I'm saying it with responsibility. So, under these circumstances, the whole notion of this compulsory rehabilitation, I think, has to be looked at much more deeply. Then there is another issue. These rehabilitation centers at the moment is found in only two places, that is Kandakada and Senapura. The Honourable Minister knows that there are serious allegations of human rights violations in both these centers. And these centers are managed by the military. It is not managed by expertise. It is managed by the military. The UN working group on arbitrary detention has in fact commented on this very negatively. And as a member of parliament who represents the Northeast, who deals with the military in a very hostile manner on a very regular basis, what I can say is that the less you have the military involved in what actually ought to be matters that they should not be involved in. This is entirely a civil matter. This has nothing to do with the military. To have them involved is really not on. And certainly from a Northeast point of view, we find it quite... I have 13 minutes. We find it quite problematic. Then, Honourable Presiding Member, Section 86(2)(a) empowers the police officer to refer a person to the government medical office, the GMO, to determine the extent of dependency. Now, the GMO can't determine the extent of dependency. It has to be a psychiatrist, a psychologist, or an expert counsellor who can, if at all, do it. I mean, all that the GMO can do is carry out a test, if at all, to see whether the person is under the influence of drugs, but not dependency. So you have someone who is going to sort of certify that a person is quote-unquote dependent, not on a scientific basis, but most probably on his own personal experience and his prejudices. So that is again something that I think needs to be looked at. And I say this, Honourable Presiding Member, because the following section, 86, subsection 2, subsection B, is quite frightening. It is most concerning because it bestows upon the police the power to refer persons to a designated treatment center if the GMO report finds the person is drug dependent. So the person who is going to certify that a person is drug dependent actually does not have any expertise to do so. And if he does it, if the GMO in fact says that a person is drug dependent, the police can directly send a person to a rehabilitation center without any court involvement. Without any court involvement. So when you have in a place like in the Northeast where you have the military and the police directly involved in the spread of drugs, and when the police have the power that has been given under this amendment, you can just imagine, Honourable Presiding Member, the disastrous consequences that the people there will be put to. I will conclude by just mentioning one more matter. Yeah, I will conclude by mentioning one more matter, and that is with regards to the way in which the amendment deals with children under Section 87. This amendment, Honourable Presiding Member, whilst might seem somewhat progressive at the superficial level, you're criminalizing children. This section criminalizes children. The involvement of a child who is under 18 years in acts that are criminalized under this law will likely be due to various socio-economic circumstances, and there would be several mitigating circumstances that will have to be taken into account. Yet instead of addressing the root causes of enabling the child to rebuild their lives, this provision criminalizes children who would have become involved in such acts due to poverty, discrimination and marginalization. And therefore, Honourable Presiding Member, I think the government should have a deeper look the government should have a deeper look specifically, and I'm saying this with responsibility, specifically because of the military's and police's involvement in the issues with regards to the spread of drugs in the north and the east. These amendments that are being proposed now might, in the overall context for the country, might be seen as something that is required because of the drug menace that is increasing. But actually, when the police and the military are in fact accused of being involved, when you look at it from that angle, I think it is very, very dangerous and requires your deeper look into it. Thank you, sir.